In this case, a stockbroking firm defaulted on the stock market, which means they were unable to supply the money for trades they had brokered. Defaulting on the stock market is one example of what's called an act of bankruptcy, so an action which, once taken, makes a person or company liable to be made bankrupt. The stockbroking firm assigned their assets to the stock market, and in the normal course of things, the stock market would then have sought an insolvency order to declare the stockbroker bankrupt. But then they realised the stockbrokers had £1,000 sitting in a bank, and this would be enough to discharge the debt. So the stockbrokers instructed the bank to release the money to the stock exchange. Here's where it gets interesting. The bank refused because there had been an act of bankruptcy, and any time within 3 months after that, it's now 6 months in Australia, a creditor could apply for the firm to be made bankrupt. So the bank's position was that the company still owned the money, but they couldn't deal with it because they had committed an act of bankruptcy. On appeal, the Chancery Court found that the bank was right. They said, "Nothing is more firmly established in bankruptcy law than that a man who has committed an act of bankruptcy is not entitled to deal with his estate. He has no right to gather it in if it is not already in his hands, or to make payments to his creditors out of that which he actually has at his command." The court outlined the rationale for their view in this way. Until commission of the act of bankruptcy, the bankrupt was the beneficial owner of whatever assets he possessed, but by the act of bankruptcy, his title to be regarded as beneficial owner is no longer absolute, but is contingent on no bankruptcy petition being presented. There would be no point even having bankruptcy law if the bankrupt could run around disposing of their assets between their act of bankruptcy and the formal declaration. This process, where a person who has committed an act of bankruptcy may not deal with their assets even before they are formally declared bankrupt, is called the doctrine of relation back. The doctrine has existed since the 16th century, and it's still alive and effective in Australia today.